All right. Good morning, everyone. It's 10 o'clock, Friday, March 22nd, and we are about to get going on our pre-hearing conference in Colorado natural gas matter. Before I call the case and get started, I want to make sure that everybody's ready to go, particularly my court reporter.
I'm ready.
There we go. Harriet's ready, so we can get going. All right. I'm going to call proceeding number 23A-0570G. This is Colorado Natural Gas's application for approval of its cost assignment and allocation manual. All right. Could I first have appearances? Who is here for CNG, for Colorado Natural Gas?
Good morning, Your Honor. Mark Davidson of law firm Fairfield and Woods, appearing on behalf of Colorado Natural Gas.
Great. Thank you so much, Mr. Davidson. All right. Trial staff?
Good morning, Your Honor. Mark Valentine, Special Assistant Attorney General on behalf of trial staff.
Great. Nice to see you again, Mr. Valentine. Thank you very much. And is Ms. Segala here with you?
Ms. Segala is here with me. Thank you.
Okay, great. UCA.
Right.
Oh, are you okay? Now I can try again. I couldn't hear
Good
you.
morning. Can you hear me now?
Yes, thank you.
This is Assistant Attorney General Patrick Witterscheid on behalf of the Utility Consumer Advocate.
Great. Thank you, Mr. Witterscheid. And last, is anybody here? I believe, Ms. Stockmeyer, are you here on behalf of ARM Heartland?
Yes, Your Honor. Gabriella Stockmeyer of the law firm Dietz and Davis, entering my appearance on behalf of ARM LLC and Heartland Industries LLC. And nice to meet you. I don't think we've met before.
We have not. Nice to meet you too, virtually. Maybe someday in person, hopefully.
Yes.
All right. Thank you all for being here. I apologize for the slightly shorter notice than I like to do. It's been a little busy around the commission, so trying to get things out as fast as I can, but this one was a little late and I apologize. And I really appreciate you all making the time despite the slightly short notice for this hearing. I called the hearing today for a pre-hearing conference to talk about the schedule. That was my intention. And I did, Mr. Davidson, get your email yesterday with the proposed schedule. In general, like this, the first thing I want to say is I've gone through it. It looks great. I think that should work fine. One point of clarification first, it looked like a 3-day hearing is planned, May 29th, 30th, and 31st. Is that right?
That's what the parties are proposing, Your Honor.
Okay.
I would anticipate it may not take all 3 days, but to be safe, we didn't want to have to extend past the deadline that you had asked for the hearing to conclude by. So there's maybe an extra day in there.
Okay. Well, I'd certainly rather do it that way and then find out that we're done early and then we're all happy, as opposed to finding out that we needed more time than we scheduled. The other question I had that wasn't clear is, did you discuss and decide on a format for the evidentiary hearing? Do you want to do hybrid, in-person, fully remote?
No, Your Honor, I apologize. I thought I would have included that in there. I think from the company's perspective, the remote hearing would be probably a preference, just because we have people in the company in various parts of the country that would likely be participating in the hearing, and then save the expense of bringing them to Denver to appear in person. So I guess I didn't really confer necessarily with the other parties directly on this topic, but that would be the company's preference.
Okay. And let me throw this out there too, Mr. Davidson. And what several companies have done is gone for a hybrid format, which allows for both, right? So that if anybody wants to be there in person, they can be, and anybody who wants to appear remotely does so. And we have nice big screens in the commission, so it works fine. But fully remote is fine with me too, if that's your preference. Let me ask the others to weigh in. Mr. Valentine, what is your preference? Nope, you're muted.
Our preference is to have the availability to do a remote. So Mr. Davidson and I have actually conferred a little bit about this. I think that staff will likely appear remotely.
Okay. Mr. Witterstein, do you want to do it that way as well? Just do this remotely?
That works. Yeah.
Okay. And Ms. Stockmeyer?
And that's fine for my clients.
Okay, so we'll do a 3-day hearing, May 29th, 30th, and 31st, fully remotely. I will so note in my procedural order. Okay. Now, the other issue, obviously, yesterday, staff filed a, go ahead.
Your Honor, sorry, before we move on from the procedural
Sure.
schedule, I just wanted to state two things for the record. First, just on the hearing, if we do have a witness, they will not be available on the 29th. So just, it's usually a courtesy to work with folks on witness scheduling. So I just wanted to put that out there.
Okay.
And then the other thing is that my clients are complainants against CNG and its affiliate in a case that's going on, 23 F0418G. And we don't have
23F, can you say that? 104?
Yes. 23 F0418G. And
8G. Got it.
we don't have any opposition or objections to the procedural schedule that's being set here, but I just want to make clear that in not objecting to it, we're not waiving any scheduling issues that might arise in the other proceeding, which is kind of ongoing at the moment. So I
Has
just
that
want to
one
make that
been
clear.
set for a hearing yet?
It has been, but we're in discussions about extending the procedural schedule. And I just, by agreeing to this, I don't want to agree that we're not making that argument in that case.
Okay. I totally understand. As for scheduling your witnesses, I generally leave that up to the parties and see if you can work it out. If I need to get involved in that, I will. But in my experience, people are generally pretty accommodating and cooperative about that. So it shouldn't be an issue, especially if we have 3 days scheduled. So hopefully
Agreed.
either the 29th, you said not the 29th, but the 30th and the 31st, your witness is available?
Yep. And I imagine the company would go first anyways, but just we hadn't discussed that. So I just wanted to throw it out there. Thank you.
No, that's very helpful. Thank you so much. Okay. Anything else that we need to discuss before we move on to the motion to compel that was filed yesterday? No, we're good.
Nothing on behalf of the company, Your Honor.
Thank you, Mr. Davidson. Okay. Shall we talk about the motion to compel then? Mr. Valentine, would you like to go first since it was your motion?
Sure. I think that the issue that Mr. Davidson raises is the request to shorten the response time. That was the issue that he raised in his email, and I understand he wants a full 14 days. We asked to shorten the response time simply because of the procedural schedule in the case.
Yes.
You know, I think it's answer testimony is pending, and I'm very cognizant that we won't even get the responses with a 7-day turnaround time for the motion, likely in time to file our answer testimonies with those answers. And so
for just a moment, Mr. Valentine, are we talking about a response to the motion to compel, or are we talking about a shortened time period for supplemental responses to the discovery requests?
it's a shortened response time to the motion.
To the motion. So we're not talking yet about a timeline for the actual.
No, I mean, that's a whole nother question.
Okay.
Mr. Davidson and I have been conferring and discussing and conferring and discussing, and we haven't been able to resolve the issues in the motion. And so that's why we filed. I don't think we're going to resolve them. And that's okay. I understand there's just a fundamental disagreement about the scope of what's available in discovery in this hearing. And I've, no problem with Mr. Davidson. He's been conferring, and that's great. But we don't think we're going to resolve these issues. Now, the moving the answer testimony to April 5th is helpful. But even if he files his response to the motion according to the request for a 7-day turnaround time, we likely will still have to wait to get the responses to these questions till after answer testimony is due. I think it was a little bit of a surprise that the answer testimony was originally going to be due next week. I mean, it just sort of jumped out of the blue, if you will.
Yes,
And
well, yeah, that was in the commission's order, so, and CNG properly complied with it and filed their stuff on time, so.
we
Yeah.
understand. At any rate, a bunch of us are out on spring break next week, and so we're very appreciative that the company has agreed to extend the time period. So, but the real issue is just we need to get the responses, and the clock is ticking in this case. So that's why we asked to shorten response time.
Let me ask you this: is there any? Does the staff need those responses to the discovery request before the answer testimony gets filed? Is it possible even to draft your answer testimony without that information?
Of course, it's possible. We, as I put in the motion, we're really struggling to understand the corporate structure and the management and how the company is run and who allocates costs and who makes business decisions. And you can read the motion. I don't want to argue the merits of that here, but we believe that our answer testimony would be better with that information. We can find other ways to do this. There's no question.
Okay. All right, then. Mr. Davidson, let me ask you to respond at this point. Unless Ms. Stockmeyer or Mr. Witterstein, do you have anything you wanted to weigh in? It wasn't your motion, but do you have anything you wanted to add?
You have nothing to add, Your Honor, beyond PCA is interested in the same issues as staff, and we'd support them in their request.
Great. Ms. Stockmeyer?
Yeah, likewise.
Okay. Mr. Davidson, can you respond to Mr. Valentine and specifically tell me, why you think you need 14 days to respond to just the motion to compel?
Yes, thank you, Your Honor. This is more than just a motion to compel. As you can see just in the caption, there's a motion to compel responses to a number of discovery requests to which the company has objected. But there's also a challenge to the designation of confidentiality. And so while Mr. Valentine is correct that we have been discussing and conferring for a while on some of these issues, I think we just have a fundamental disagreement about the scope of some of the discovery propounded by the staff on the company. And I will point out that a number of the objections to the discovery request that staff now seeks to have you compel us respond to, we objected to 2 months ago, and staff waited until yesterday to file this motion to compel. And seeking to, shorten the response time squeezes the company's response to what I consider to be a fairly substantial motion at this point. There are a number of questions that the staff is seeking to have us respond to that we object to, and I think appropriately, and we'll address those issues in the response when we file it. But I think requiring the company to respond to a fairly complicated 10-page motion at this stage in the case is inequitable from the standpoint of what our burden is to prove our case as the applicant here. And so I understand that staff may be pinched for time now, but it's not incumbent on us to address these issues in half the time that we're entitled to pursuant to Rule 14D or 14B in the Commission's Rules of Practice and Procedure. And so I think that we're entitled to the full 14 days to address not only the motion to compel aspect, but also the challenges to confidentiality that the staff has raised in this motion.
Okay. Got it. And you're right, it is a lengthy, complicated motion. I did not even have time, to be quite honest, I read it through quickly and fully, but not thoroughly, if that's fair. So I have read it. I did take it in, but I can't say that I've analyzed every issue yet. Just haven't had the time. Okay, let me throw this out there because let's take this apart and do one issue at a time. The first issue, obviously, is the time period for responding to the motion to compel. And I think staff has a valid point. We are on a time crunch, and regardless of when the motion got filed, the time crunch isn't going to change. So, but I do appreciate that CNG needs ample and sufficient time to respond. So what if we kind of split the difference? Would a response time by, say, oh, shoot, of course my calendar's on the wrong date. So full 2 weeks would put it at April 4th. Is that correct? I think.
I think that's right, Your Honor.
Okay.
That's right.
That's right.
Yes,
Okay.
that's correct.
And right now, answer testimony, it's going to be due April 5th. And it looks like that's what we're going to stick with that date because I don't, and we'll do any supplementing later we need to. But what about getting a response into the motion to compel by Tuesday the 2nd? That shortens it only by 2 days. And that still gives staff a bit of time to take in the response and prepare answer testimony in light of the responses to the motion to compel. Does that seem reasonable to you, Mr. Davidson, Mr. Valentine?
Well, on behalf of the company, of course, we prefer the full 14 days, but I think we could probably accommodate this given the circumstances. I will point out, Your Honor, that, as you observed in your order setting this pre-hearing conference, the original date for answer testimony was March 7th, pursuant to the commission's notice. You were generous in providing an extension to March 29th to the interveners, and the company has agreed to another week for the parties to respond to file their responsive answer testimony. So we have done what we were supposed to do, as you observed at the outset, and filed our direct case. We're now disputing this motion to compel, which, as we acknowledge, is complicated by the challenge to confidentiality as well. So I would say we can do it in 2 days less time to accommodate the procedural schedule that we've agreed to, but I just want it to be clear that the company feels that it's being pressured on the back end here for doing what it was supposed to do on the front end. So
right, and thank you, Mr. Days, and I do appreciate that, but the time pressure is what it is. So
understood.
Barring the company's waiving the statutory time period, it is what it is, and we really don't have a whole lot of control over it. So we still have to be mindful of that and make sure that things can get done. So I'm hoping just two days shorter still gives the company 12 days to respond, which should be enough time. And I'm talking close of business on the 2nd. So
we can make it work.
That would be perfect. Mr. Valentine, does that sound agreeable to you?
It does, and Mr. Davidson and I have discussed waiving the deadline. I don't know if the company is amenable to that because, I don't know their internal process, but there is a CAAM in place right now that is functional, and the company is using that and taking care of its cost allocation pursuant to that CAAM. I don't know if CNG has any input on that.
Well, and I will note, if that is an issue mostly for CNG to determine, but it is something to consider. This proceeding has raised some pretty complicated issues. There's some, real structural corporate entity kind of stuff that we need to get into, I'm afraid, and that may take a little bit of time. So, waiving the deadline is an option, and if that were to be done, we could dispense with this tight schedule and give ourselves some breathing room, but that is entirely up to the parties. So, I will let CNG and its counsel, Mr. Davidson, determine whether that's something they wish to consider. But right now we've got what we've got. So an April 2nd deadline to respond to the motion to compel. Let me ask you this. Assuming, and I haven't made any determination on the motion to compel yet, but what did Mr. Valentine, should a decision come down to require supplementation of the discovery responses, when are you looking to get these answers supplemented?
It's a good question, Your Honor, and I don't know the answer to that. I would hope that the company has answers, but they could make other objections too. So at any rate, I don't know the answer to that. I mean, Mr. Davidson's point is well taken. I would appreciate the 10th, but the reality is that we may not have the answers by the answer testimony deadline in any event,
It
right?
doesn't seem likely, no.
Yeah.
Okay. Okay. So the response will be filed on the 2nd. Answer testimony is right now due on the 5th. And the only suggestion I would make, well, I don't even want to say this. It does seem feasible to push answer testimony until the 12th, and then maybe that would be time to get responses. But Mr. Davidson, what do you want to do something like that? What do you think?
Well, but the problem there, Your Honor, is it then shortens our response time in our rebuttal case by a week.
Correct.
And that's
Yes.
part of the problem here. We're getting pressed
Right.
on the back end
Right.
because of delays on the front end by the other parties. So
Right. Yeah, no, I absolutely appreciate that. Right now, you've got it set for about a month to a little less than a month,
right.
28 days, I guess, to look at the rebuttal. So that would shorten it to just 21 days, which is tight. I completely agree. So I am fine with April 5th if everybody else is. I'm just trying to think of ways, because I am concerned that what's going to happen is, we're going to go through this motion to compel, and the discovery responses, may or may not be supplemented and may lead to additional needs for discovery and additional testimony. And then we'll be really crunched on time because the hearing will be, a matter of a month or two, a month and a half away. So it's going to be tight. But if the parties feel that this schedule will work, I'm fine with working with it. So we're good then?
Your Honor, just a question or a thought.
Sure.
So we have an answer testimony deadline, and we have a deadline
Mhm.
for corrections. Could we
Yeah.
add in a deadline to supplement as necessary, or else have just have it be clear that the rebuttal and cross answer could include this supplemental information that's potentially
Right.
learned?
I think that's a good idea, Ms. Stockmeyer. Yes, right now we've got answer testimony April 5th, rebuttal and cross testimony May 3rd, and corrections to testimony May 24th. But we could put let me pull up another calendar, a date in the middle of that, say May 3rd, say like May 10th. Is that reasonable? That's only a week after the rebuttal, but I don't see having a whole lot of additional time beyond that. But we could add a deadline on May 10th for any supplemental testimony based on discovery responses. Mr. Davidson, what's your thought on that?
Well, being the moving party with a burden of proof, we would need to reserve the right to respond to whatever supplemental testimony the parties may offer on potentially May 10th. So,
well, we do have the May 24th corrections testimony, so we could throw that in and just make that rebuttal and corrections. We're adding in a lot, but I'm trying and make sure everybody has time to get in what they need.
We are adding in a lot, Your Honor, and I appreciate your attempt to accommodate all of this. I don't want to squeeze Mr. Davidson too much because, staff it understands that the utility in this case has a lot going on. They're about to have another case.
Yes.
And then there's Ms. Stockmeyer's formal complaint case. And so I don't want to overwhelm Mr. Davidson, and I want him to have a fair opportunity to respond and rebuttal. And I think, I appreciate your willingness to try and find some spot for supplemental testimony. At this point, I think that, we filed our motion to shorten the response time simply because we know we're not going to get the responses likely by the time the answer testimony is due, but we're worried about this dragging out even further. And so, if we file cross answer testimony or or even to get ready for hearing, we would like to have the responses sooner rather than later. So I
Okay.
suggest that we go with the 10-day response time, or 11 days, the second, and then staff will have to figure out how to use the answers that it gets.
Okay. I am fine
And
with that. I mean,
they will still be informative. Don't get me wrong. And, you know, if the company at some point wants to waive the statutory deadline, that can provide relief. As you point out, that's up to them. I'm content with just having the deadlines as you set them.
as we have it now. Okay. And,
Yep.
and Ms. Stockmeyer, I would also remind you that, it is also true that we are planning on having a full evidentiary hearing. So if information is brought up through discovery and additional information is obtained that needs to be looked into, certainly everyone will have the opportunity at the evidentiary hearing to question witnesses about it. So it's not like you won't have a chance to respond at all. It just might not be through pre-file testimony. But Mr. Valentine is right. We need to make sure that everybody has enough time to respond and take it all in and prepare for the hearing. All right, so let me just put it on the record. Here's what I've got. We've got an April 2nd response to the motion to compel. April 5th, the answer testimony. May 3rd, rebuttal and cross testimony. May 22nd, settlement or stipulation deadline. May 24th, pre-hearing motions due. Also May 24th, the cross-examination matrix due. May 24th is also any corrections to testimony. Then the hearing will be May 29th, 30th, and 31st, and statements of position on June 14th. Does that sound like everybody's in agreement on that? Okay,
Yes,
that's
Your
what
Honor.
we'll put in the order then. Okay. Anything else we need to address?
Not on behalf of the company, Your Honor.
Thank you, Mr. Davidson. I appreciate it. And Mr. Valentine, anything on behalf of staff?
No, that's it. Thank you, Your Honor.
Great. Ms. Stockmeyer?
Nothing further, Your Honor. Thank you.
Okay, Mr. Witterschein? Oh, your mic keeps cutting out, Mr. Witterschein. I can see you're not muted, but your mic cuts out.
No, Your Honor. Nothing from UCA. Thank you.
Thank you so much. And let me just say, Mr. Davis and Mr. Valentine, thank you so much for being cooperative and working together, and to all the parties for coming together and getting the schedule. It makes my job much easier. So I'll look forward, Mr. Davidson, to getting your response to the motion to compel, and we will move forward once we've all reviewed that and taken it in.
Thank you, Your
All
Honor.
right, thank you all for being here this morning. I will get the procedural order out as soon as I can, and we are adjourned then.
Thanks.
Thanks so much. Have a good day, everyone, and a good weekend.
Thanks, Alenka. I got